I think Justice Sotomayor.
Mr. Gannon, let me start with what other aggravated felony is defined merely by the dictionary? Because that seems to be what you're doing. Tell me what other identified aggravated felony do we approach that way?
Well, you approached the sexual abuse of a minor offense in Esquivel-Quintana that way. You used other sources, and we, too, are using the same sources that you used in Esquivel-Quintana to say that—
we were just defining, in that case, we were using the categorical approach and looking at common law elements and figuring out what they meant. Now, assuming that I think the other side has a point, that we have to find what the definition is of obstruction of justice or relating to obstruction of justice. All I can find is that in 1831, leading commentators Blackstone and Kent understood it to require a pending petition. In 1893, the court in Pettibone held that obstruction of justice requires a pending petition. Congress reenacted the offense in 1948, explaining that it made no substantive change to the petition at the time of Pettibone. Then in 1995, just 1 year before obstruction of justice was added to the INA list of aggravated felonies, the court in Aguilar again required interference with a pending proceeding. Now, you say some states in 1996 had expanded the definition of obstruction of justice not to need a pending proceeding, but the majority of them still defined it that way. I look at how Congress used it, and in all of the federal criminal code, the phrase relating to obstruction of justice appears in just one other place, RICO Section 1961. And it specifically refers to 1503. That same provision refers to Section 1512 as relating to tampering with a witness. So Congress itself is now saying we think of obstruction of justice as something different than the other provisions. And if we read things the way you're saying, there's a lot that's superfluous in this statute. Why would Congress have made it necessary to point to perjury or to false statements or to other provisions that it did? I'm a little bit confused. I would think that we would go to what the common law understanding was at the time in 1996. And in 1996, every use of relating to obstruction of justice required a pending proceeding.
Justice Sotomayor, we do not disagree that 1503 is an obstruction of justice offense. We disagree about the idea that that's the only obstruction of justice offense in federal criminal law. And
no, you're missing the point. The point is, what are the elements of an obstruction of justice? And if it required a pending proceeding,
yes.
How do we read it out?
Because we think that you have to look at more offenses than 1503 in order to determine.
But when Congress did that, when it referred to 1512, it said relating to tampering with a witness, not relating to the obstruction of justice as it did in RICO.
RICO is the only place where it does that, and the two parallel cross-references that you're talking about.
Why bother with all the other definitions, perjury, all the other crimes? They all relate to obstruction of justice according to you, with or without a proceeding.
I think the aggravated felony definition is replete with potential overlap. Congress clearly wanted this definition to be broad. It returned to it several times in the 1990s in order to make it broader, in order to reduce the punishment thresholds. It reduced the punishment threshold here from 5 years to 1 year. And there are other things that clearly overlap in the aggravated felony definition.
There are many states that make it a crime not to report a crime. even if the person hasn't aided or abetted or participated in any way in the crime or helped the criminal. Is that an obstruction of justice offense?
Only if it has the specific intent requirement to interfere with an investigation.
But
and
it
what we are
seems to me
saying
you're
is that
reading that intent into everything. So is the BIA. You're saying that just because an investigation might follow, you're responsible.
we read that intent requirement by looking at the dictionary definitions, the commentators, the model penal code, lots of other things that had happened in the law after Blackstone in 1831.
Counsel,
we take Pettibone and
okay, why don't you finish your answer to Justice Sotomayor, and then I have.
we take Pettibone and this court's decision in Aguilar in 1995 as saying that 1503 did have the pending proceeding requirement, but we think it's clear that Congress considered a larger range of offenses, including those that are in Chapter 73 as also being obstruction of justice offenses, and indeed Section 3, the accessory after the fact provision, which federal courts of appeals since the late 1960s and early 1970s had repeatedly characterized as saying the gist of an accessory after the fact offense under Section 3 is obstruction of justice. We think that is part of the context against which Congress enacted this definition in 1996.